I think the concern that regulators would have is that you are inhibiting other people's right to contract and the right to work. I think that's a public policy concern. So I don't know. I haven't had any clients try that yet. But it seems like, that's something that could and should be considered. I just don't know what a regulator would, if they look at the contract and see that, what they would think about that.
Have you heard anything in Starbucks along those lines that you felt good about?
Well, I think that's what she said. They haven't. No. Yeah, they haven't received legal blessing.
We're not.
From any great ideas.
We haven't. No, I mean, no, and I think. Just the piece I would add to what Montaye just said is I think it also is dependent on the specific language of the specific state's conversion statute, because we've seen different kinds that do different things. Having, making sure your operational agreement, your contract has a severability provision that has all the sort of standard protections in it so that if you have to strike a provision, the rest of the contract can hold up. That's the kind of thing you want to be, cognizant of too.
And if you're using like a template agreement, and it has a conversion fee in it, you should always preface that with we're not prohibited by applicable law, right? That doesn't mean that your contract otherwise complies with every state law, but there are enough states now where conversion fees are either prohibited, restricted, or it's a gray area that you wouldn't want to just include, I think, a conversion fee provision without some sort of carve out for states where it's questionable, right?
And the other dynamic that's really unique, I had a member firm call me, and he had a situation in New York where the client took the doctor. It was an orthopedic surgeon after a week or two work of work, 2 weeks.
Yeah.
What he realized was problematic was not necessarily the cost associated with finding the orthopedic surgeon and getting him there. Helped him get licensed, actually imported. It wasn't even a New York resident. So it was a good recruiting effort. It was a valuable service to that client. He was very concerned about the malpractice exposure on his policy for those 2 weeks that he couldn't quantify the day that doctor left. Now we try to quantify it through a conversion fee, and and we carry that exposure for us for several years into the future. And he now had 2 weeks worth of malpractice exposure from an orthopedic surgeon at that client that he has to carry now and hope that nothing happened in those 2 weeks. And he got no compensation for it. So that's another wrinkle kind of in our business with malpractice being such a major line item, major expense for our business, and it's always evolving. So, Dave, you had a question?
Is it fair to say that some of these states that are in the prohibited or restricted categories, some restrict the conversion fee specifically, and some actually prohibit any restriction on employment whatsoever? Is that a fair statement? Like I'm thinking about Washington, for example.
Yeah, that is a fair statement, and we don't know at this point how broadly those prohibitions on restricting employment opportunities are going to be interpreted. So, I don't know at this point that it's fair to interpret that as a prohibition on a conversion fee, right? It's not something that's being charged to the worker. But conceptually, could a regulator take that position? Sure. We haven't seen it. I haven't heard about that happening yet. But yeah, those provisions are super vague, and we don't really know how that's going to shake out.
Yeah, it seems to me that they could be ideally interpreted very narrowly, like you said. They could also be interpreted very broadly, such that anything that would even cause a bump in the road is a restriction.
Yeah. And that's, to me, very unfair. Obviously, we in this room would argue for a very... we would argue for a very narrow interpretation.
Well, on that note, let's talk about something exciting. I think we're up in New York, right?
Yes.
Next case.
Yes. So we were going to talk about what to do, and one of the things about what to do is with NALTO.
And I think this conversation today reaffirms that. Quickly, in Louisiana, we did do some effort to get some clarification from the legal department within the state of Louisiana that law does not apply to CRNAs. It feels like as you read it, there's some ambiguity, but then when we reached out to them, they were like, there's no ambiguity. It doesn't include CRNAs. What are you talking about? And we're like, oh, great. That's all we needed. Thanks. Thanks. Have a nice life. So New York, I'll give you a little bit of the history on how we started this with New York. We evaluated with the legislative committee how to carefully invade the state of New York without maybe drawing pressure to any one agency or NALTO or locums, thinking maybe naively that they don't know who we are. And so we, as a legislative committee, we got a recommendation from James Hauser at IA. They had spent some time in New York on the nursing side of things and had come across Constantinople and Vallone is the name of the firm that we engaged with. And they turned out to be the right firm for us. They have a lot of great connections with the legislators at the state of New York and the Department of Health. So we got with them and we started strategizing about how could we dispute this disconnect between what the legislation appears to say and what the Department of Health put on their FAQ website where it says, does this apply to locum tenens and advanced practitioners? And the answer is yes, of course it does. That's what the Department of Health said. But we felt like there was a disconnect. And so in talking with them, we strategized on let's go after the definition of direct care worker, which is what it says in the law. And it is broad. The Department of Health has specifically said, well, we think it's broad enough that our legal counsel has determined that direct care worker includes physicians and advanced practitioners. We were fortunate enough, I know Eddie was on the call, Anthony was on the call to speak with the director of the Department of Health. She, a very kind lady, she was very nice to us. She knows who we are, she knows what locums is, and we kind of gave our perspective, which I think appears to be the theme across the country, which is, what was the intent of all this legislation? Like, when did it start? Why did it happen? And what was the intent? And it appears that it was certainly for, sort of the surge in demand with nursing through COVID, the surge in bill rates, the concerns that hospitals were clamoring to their legislators about, hey, what can we do? We can't get people, it's too expensive. But from our experience, right, we didn't see that surge in locums, right? I mean, certainly demand has been higher than ever post-COVID, but the surge around the cost has not been quite what they saw on the nursing side. So, look, if that was the intent, are we victims of, some unintended consequences? So we sort of pitched that to them, like, hey, guess what happens? Like, let's tell you a couple, cute stories about a doctor who we brought into the state. And it's our estimation that if the regulations are too difficult in the state of New York, and they're not as difficult in the state of Maine, and we have a doctor licensed in New York, we have a doctor licensed in Maine, what do you think is going to change in the recruiting behavior, right? Even if the executives at the company say, hey, don't change your behavior, we all have recruiters. Recruiters go where recruiters go, right? We know their behaviors at times. And so that was sort of what we were pitching to them. And so understanding that landscape, we pivoted to the definition of direct care worker. Our lobby firm is kind of the ones that they smoke the cigars in the back rooms with but when we need legal work done, we get Montaye. So Montaye wrote a nice little piece for us, and we're still refining it because the Department of Health has given us a window of opportunity to submit a rebuttal to their position, whatever their legal department came up with that said, yeah, throw it on the website, put it on the FAQs, it includes physicians, right? We think they're usurping their power to legislate, and we think the legislation just shouldn't include them. And then we're also working on maybe kind of what was the legislative history. Did it at one point include physicians, and then it got taken out? I mean, the Department of Health and the senior staffer for Senator Rivera, I don't know what district he's in New York, but he's the healthcare chair. They both said on the phone, oh yeah, I was in the room. This was supposed to be for nurses. Yeah, we get that, but direct care worker includes physicians. So we're really pushing on that and trying to draw some lines between what other states define a direct care worker as, what the Department of Labor has used that definition as. So Montaye did a great job kind of crafting an argument. And so we're hoping in the next couple weeks we can get an audience with the Department of Health's legal team to challenge that. If we lose there, then maybe it's back to the legislators to say, hey, Department of Health is, we're not getting anywhere with them, and you guys are the ones who made the law, so see what we can do there. That's plan A. Plan B would be a pivot, and we don't want to hint to that pivot, but they have clearly indicated that their compliance rules are too much. In fact, Senator Rivera's health guy said, yeah, we're looking at the quarterly, like, what would you guys prefer? Would annual be better? We're like, well, of course annual would be better. And so we feel like there's a lot of room to maybe ease things if we can't win the ultimate prize. So Eddie, Autumn, Anthony, anything to add? Aj, is that a good summary of kind of where we're at with New York? Yeah. So we think we've got a nice path there, but we're spending all of our money collectively, so I think it's helpful to go into detail of kind of where we're at with New York. So that's really kind of where we're at on advocacy. We haven't focused on really any other states because what we're hearing from membership at this point is, what's going on in New York, right? I get a lot of phone calls from it. Clearly there's a lot of excitement. Any questions on kind of where we're at with New York? Any other states you think we should be looking at in parallel with New York?
I like Step Brothers, so can we register?
I will tell you, I've looked at the list, and I will say it appears that, excuse me, a majority of NALTO members have. It appears. Like if I look at the list, their name's on there. I had to look at that list because I think I had said in our first call with Senator Rivera's staff, like I said, I don't think our membership is fully compliant at this point, right? Because there's ambiguity. And I think I was wrong in that. There's a lot of people registered. Now, whether they're sending in their contracts 5 days after execution, whether they're doing the quarterly reports, I don't know. And as and as we've heard, there's been a couple inquiries, but it doesn't seem like the heat on enforcement is quite there yet. But I don't know if that means it's not coming, right? I mean, she was a nice lady, but I mean, she sounded like she was intent on enforcing compliance. I mean, I didn't sense that she was like they were just going to gather data for the heck of it. So, good question. So, did you want me to say yes or no? Go to the website. You can see who registered, and you can be like, well, do I want to register? That's what ask the attorney. They're going to say, get registered. I mean, the penalties are severe.
Yeah.
It's what is it? It's a civil penalty in New York.
It is.
$10,000 per.
I don't remember off the top of my head.
It's something.
But yeah,
I think it's a per infraction.
It's significant.
Eddie, do you know what's the civil penalty? Is it per infraction in New York? Okay, so there's some debate around that, but it's enough that those that have volume there are very concerned about the penalties, right? And their decision to register is closely connected to the penalties. So that becomes a business decision. Any other questions? Okay, who's wrapping up on your guys' side?
We're going to skip this slide. We've sort of talked about this in passing as we've gone along. Yeah.
It's comfortable in these chairs, isn't it?
I feel like I've had a chance to. Does anyone do business in California? Okay, so if we're going to talk about New York, we also have to talk about California. And again, this is just good for you to know in case you happen to run into a friend who might need some help in California. Okay. Couple, just again, along the lines of like new regulation, new law that's good to know about that may affect your business. We actually have new law in California, newish law in California that is super relevant to litigation risk. And so the first thing is it is now clear in California, it was not clear for a long time, but it is now clear in California that it is permissible to mandate an arbitration agreement with a class waiver, collective action waiver, as a condition of either employment or placement if you have an independent contract. It is a decision, whether to have an arbitration agreement is one to think about and discuss, but it allows for the private resolution of legal disputes, and of course it avoids those types of mass actions. So we generally recommend discussing with your counsel whether it makes sense for you to have an arbitration agreement. And I'll tell you, as I just said to Eddie before we started, that all of my sexy cases have gone away. That's because all of my clients now have really good, I hope, unless we didn't draft them, arbitration agreements with class waiver. If you have an arbitration agreement with a bad class waiver, please let me know, because then I might get excited that there might be something wrong. Look at those are really important. The California legislature amended the PAGA statute at the end of June. And this, for anyone who's dealt with the Private Attorneys General Act in California, this is a huge deal. The Private Attorneys General Act is a statute that allows for an individual to stand in the shoes